It's a pleasure to welcome you to this evening's program, Meet the New Judges from our San Francisco division as well as our San Jose division. My name is Randy Sue Pollock, and I'm president of the Federal Bar Association for the Northern District of California. Tonight's program features, it's been long overdue, but we have to wait for Judge White to be confirmed last December 2024. President of our San Francisco division is Judge Thompson, who was sworn in August of 2022. It's been a while. Judge Martinez Altman, who was sworn in March of 23. Judge Pitts from the San Jose division, who was sworn in July of 2023. Judge Lee, who was sworn in March of 2024. And Judge Weiss, December of 2024. Judge Lynn, unfortunately, had a conflict and couldn't be here this evening. So we're going to begin now. I'd like to start with asking each of you to talk a little bit about your personal and professional background, what your path to the court was, and anything interesting about your background.
I'm going to keep it really short because some of you have already met me and appeared in front of me and corrected me when I've made mistakes. And I thank you for all of that. I'm Judge Trina Thompson. I started out as a public defender in Alameda County. Thereafter, I had my own law office where I handled capital litigation and homicide cases for close to 15 years. Thereafter, I became a juvenile court commissioner in Alameda County, and I sat in that role and transitioned to the Alameda County Superior Court, where I served for a total of 20 years. And then was transitioned here to serve as a federal court judge, and my courtroom's right next door. It's been a pleasure to come to this courthouse, particularly when a lot of my mentors have come through here. And to see their paintings on the wall, to see correspondence at my desk that represents one of my mentors is always a very sobering moment. And for all of you who are here, given these turbulent times, those of you who are working within government offices, I applaud you for being here today, because I know that things have been a little rocky, things have been a little tough, and morale has been up and down. And for you to show the dedication of being here tonight is pretty extraordinary. And I applaud you for being here, because I know that it's an additional sacrifice.
Since I've been on the bench, I'm getting quite a bit of experience. And those of you who know me when I'm not on the bench, people in the community know me more as a photographer or as an artist. So that's how I spend some of my downtime in order to relax. And otherwise, I'm my grandson's taxi cab service until he gets his license.
Thank you.
Good evening, everyone. I'm Araceli Martinez Holguin. I grew up mostly in Sacramento. I'm a Mexican immigrant, but Sacramento is where my family ultimately landed when around the age of 8. I went to college back east, came back. I was a bilingual kindergarten teacher for a couple of years before going all the way to Berkeley for law school. I taught in East Oakland, so that's a bit of a joke, the very far distance from East Oakland to UC Berkeley Law. I clerked for a federal district court judge in the Western District of Texas in El Paso. I should not gloss over that as a law student, I worked for Judge Henderson as an extern, so I am familiar with this building in that way before getting chambers here on 19. Like Judge Thompson, my courtroom's not far. I'm farther than hers is. I'm on the other side of that hallway. My career as an attorney was spent working as an impact civil rights litigator, most of that work on behalf of immigrants. Of my 18 years, I spent 6 of them at the ACLU, a part in the Women's Rights Project, a part in the Immigrants' Rights Project. I was also a federal employee for a period of time beyond my federal clerkship. I worked at the U.S. Department of Education Office for Civil Rights. I founded and directed a small program dedicated to immigrants' rights litigation at Community Legal Services in East Palo Alto, and also worked at what is now called Legal Aid at Work. I think those are all the jobs I had. I was a career public interest attorney, and for those of you who might not realize, that is what public interest careers look like. You hop around a little bit here and there. So let's see, what else did you want us to tell these folks, Randy Sue? I'm thinking about with Judge Thompson's wonderful comments commending the folks who continue in their federal employment and the tough times that we're in. I think the other piece I'll just share with you is touching on the thinking of your grandsons. I'm like, I'm not quite a taxi service only because my spouse is kind enough to do all the shuttling of our 11-year-old, most of the shuttling of our 11-year-old around, and in my free time I do whatever that child will let me do with them. I'll pass it on to Judge Pitts.
Thank you. I'm Judge Casey Pitts. As mentioned, I'm in the San Jose division. A little bit, I guess, about me. I was born in Moorhead, Minnesota, and spent the first 18 years of my life in Fargo, North Dakota, which is really where I live, just across the river from Moorhead, Minnesota. So still a huge North Dakota State University Bison fan and watching the football games every weekend. So was in Fargo for my whole childhood and then went to the East Coast for college. And then made the fortunate decision to move out here after college to work as a paralegal to figure out if I wanted to be a lawyer, figuring that incurring all that debt without any idea of whether I actually wanted to practice law would be a good idea. And it was a very fortuitous decision on a lot of fronts, and including making me a diehard San Franciscan for life. I did leave to go back to the East Coast for law school, but knew that I was always coming back to San Francisco. It was where my boyfriend was, and it was the place that I loved more than anywhere else in the world. And so I was kind of here every 4 to 8 weeks all through law school anyways, and every summer. And after law school, I clerked on the Ninth Circuit for Judge Reinhardt, so I was all over, but I actually kind of like the stories of this building. I was very fortunate that the year I was clerking was the year that Judge Reinhardt was sitting on a 3-judge panel with Judge Carlton and Judge Henderson deciding whether to order the California prison system to reduce the prison population because doing so is necessary to provide constitutionally adequate mental health and health care in the system, in the case known as Plata versus Schwarzenegger. So we were in this courtroom for several weeks hearing all the testimony in the trial, with the 3 judges up there and us sitting in the corner over there listening, and then preparing, the last few months of my clerkship was preparing a 200-page order requiring a reduction in the population of the California prisons. So I also got a little bit of the experience of being in this building and working on the district court in that context, which was wonderful. And after I finished with Judge Reinhardt, I ended up going to Altshuler-Burzon as a first-year associate, which is a public interest firm here in San Francisco. And I did complex impact and appellate litigation on behalf of workers, labor unions, consumers, environmental groups, other nonprofits, government entities, as well as some civil rights impact and class action litigation. And was there for 15 years and becoming a partner in 2017, and expected that was where I would spend my entire legal career, and in a very interesting and diverse practice there. But I was fortunate in 2022 to be nominated to this position, and after a somewhat long process, although we know many people who waited much longer than we did, including Judge Lynn, who had to wait 3 months longer than either of us, and all of us had our own stories. Was fortunate to get through that process. And so I'm now a little over 2 years on the bench down in San Jose, and I'm really enjoying it. I guess if we're talking about, I don't have any children that I need to taxi around, but I do have, and will be immediately after this, picking up my dog, with whom I share joint custody with my ex-husband. So we're doing the switch off tonight, and I'm excited to go pick up the dog and have him as soon as we're done here. So if you see me leave the reception early, it's because I'm going to get the dog.
Co-parenting obligations. Yes. Hi, my name is Yumi Lee. It's nice to see everybody. So I joined the court about a year ago. Like many, grew up outside of the state, was born in Wisconsin, grew up in Tennessee, went to college out west near Los Angeles, and then actually found myself in the Bay Area for the first time, teaching in East Oakland as well. I feel like I'm very loud, so I'm gonna drop this a little bit. So taught in East Oakland, fell in love with the Bay Area, like many of us do, and went to law school on the East Coast, but then just kept coming back to the Bay Area. So a lot of my experiences over the summers were in the Bay Area, ended up clerking, going back to Tennessee to clerk on the district court, but then worked for law firms out here in San Francisco. So both Thielen, Reed and Priest, as well as Kecker and Van Nest. In the middle of those two law firms, I also clerked on the Ninth Circuit for Judge Ferguson, went back down south for that experience, but once again, came up back to the Bay Area. So after finishing about a number of years in private practice, I decided to become a clinical professor, returning to sort of my public interest roots, teaching in a civil justice clinic, doing employment, housing, and benefits cases, and then also opening a reentry clinic. I taught criminal procedure and ethics, but then also sort of expanded a lot of my research into privacy, and so did a deep dive into privacy for a while and technology. So finished that time period within a UC Law, Hastings, now UC Law, and then after that was appointed by Governor Brown to the bench, and so served in Alameda County Superior Court, both on a criminal and civil dockets, and then was lucky enough to be nominated by President Biden as well. Had been with the court a little over a year, July. So I was confirmed in March, but started in the end of July of last year. And also down in San Jose, where my neighbors and my dear colleagues, my neighbors in the East Bay and my dear colleagues next door, my neighbor in terms of our floor. Trying to think of outside of that, fun things or other things about me. I enjoy all Bay Area restaurants. I'd like try to find little nooks from the hole in the wall through the fancy places. Like to cook similarly across the board, all different types of food. And am also a taxi cab driver for my 10-year-old as well. Which luckily my spouse is very kind in terms of helping in a great part in terms of those shuttling services across the Bay Area.
Good evening, everyone. Can you hear me okay? Yes. I'm Noelle Wise, and I am also sitting in San Jose. People took a pretty deep dive starting with where they were born, so I'll try to be quick. I was born in New Jersey. We moved to California, the Central Valley, in the 70s, where I finished up school. There were very few people in my extended family on either side who had ever gone to college, and so the people who did were all teachers, so I started off as a high school English teacher. And I did not have a very thoughtful path to the practice of law. It was, I had been thinking about some sort of graduate school. I was thinking I might want to go to medical school. I was curious about something that was kind of an early version of Doctors Without Borders. That seemed very interesting to me. I saw a sign up for the LSAT. I did not know what that was. I incorrectly believed it was like a Rorschach test to help one decide whether law school might be a good idea. I'd at least been to a doctor before. I had never met a lawyer, let alone a judge. So I went and sat for that, thinking it might be interesting. That worked out well for me. I recognize that that's not a typical thing, but at the time, because my mother had been a math teacher and my dad had also been in education, and none of us had cell phones at the time, when we would take family trips, they would give me logic books. And so I grew up doing logic problems for fun, and so it was well suited, I guess, to the LSAT at the time. But I taught high school for a while. I ended up going to law school. When I finished law school, I clerked for Justice Anstead. He's best known for being the Chief Justice in the Florida Supreme Court during the Bush v. Gore hanging Chad debacle. And from there, I went to the honors program at DOJ, and where I worked for about 7 years doing civil and criminal environmental law, and then a stint at the U.S. Attorney's Office. down in San Diego for a period of time. Moved back to California when my father became quite ill about 26 years ago. And from there, I continued to work for a while at the Department of Justice. I was contemplating about whether I wanted to teach law school full-time. I was teaching a little bit at Berkeley Law at the time. I taught for a little bit at Stanford and decided I really continued and enjoyed the practice of law. I worked for a while in-house at PG&E on both the legal side and on the corporate side. I was the director of power generation, which is a whole nother conversation when they asked me to do that. And I said, you do understand, I don't actually know how power is made. And they were like, oh, it's not so hard to learn that part of it. But I had a small women-owned law firm for a while. I was really captured counsel doing energy and environmental practice. I too was appointed by Governor Brown almost 10 years, nearly to the day, before this job. So I was on that bench for 10 years doing a mix of things. I started off in family. I ended up supervising our civil complex unit that was there in the interim. I had a 1-year stint at the Court of Appeal and started here in December. And my kids are a little bit further along. Not only am I not taking them anywhere, but because we are still paying the insurance for the kids, we say that the exchange is that they have to always be our Uber driver whenever we want. And so one of my daughters is named Grace, and she calls herself the Gruber. She's looking forward to, not as much as I am, but when she's paying for her own insurance, and apparently won't have to provide that service any longer. But anyway.
Okay, thank you. I'd like to direct the next question, or my first question, to Judges Thompson, Lee, and Weiss, because you came from state court. What has the transition been like for you? Are there things, was it a challenge adjusting to federal court? Are there things you missed from state court? Things you'd like to import over from state into federal? I'll turn to you first, Judge Thompson.
Well, I'll start with where I ended when I was in Superior Court in Alameda County, and I was handling complex criminal. And it was a pretty amazing assignment in terms of the kind of cases that we were getting. And they stacked the cases. You're in trial, another case is coming right behind it. But in state court, you specialize for the most part during your assignments. And so you're either working just in the family law department, complex litigation, or in criminal, and you gravitate towards whatever is your expertise towards the end of your tenure or your last 5 to 10 years. While handling those cases, particularly the ones for sentencing, in state court, everything is pretty much a triad. And so you know that you start with the midterm and you work your way up. If there's aggravators, you work your way down if there's mitigators. And then there's cases that, of course, have a life top, and you know which ones those are, and you know how to handle those. Coming here, just having to ask questions, and when I probe about certain things, people would look at me somewhat odd, or I would say, counsel, can you share this, or can you share that? And they didn't understand why I was asking those questions. But in state court, you start to realize you have an opportunity to not only shape your next door neighbor, but whoever's in that audience who may have come with that individual. And the more you educate on why you're sentencing a certain way, what are the aggravators, what are the mitigators, people begin to see the transparency in the sentencing model. And they may not like what your ultimate outcome is, but they know how you arrived at it. And so even now, it's a part of my DNA in terms of sentencing. I still do that. I will tell the parties, I've read this. This is what I received from the sentencing memorandum. This is what I was able to extract from defense memorandum. This is what I received from probation. And then allow the defendant to be the last voice that I hear, to talk about what it is they would like me to know about them as an individual. Because you don't know the impact you're going to have on people when you just are present and you meet them where they are. Because many of the people that come before us are going to return to the community. And when they return to the community, you want to give them some hope or some direction on how to either correct their behavior or to do better or to get resources. One of my proudest moments was just 2 weeks ago. When I was in juvenile court, we had some young men who we were at the camp, and one of the young men fell out. And they knew what to do. And I said, how did you know what to do? And they said, well, in our community, ambulance is not gonna come in time. We can't afford medical care, so we had to learn what to do. So these young men enrolled in the EMS Corps after they finished their juvenile court stint. They went on from the EMS Corps, which is emergency medical services, on to firefighting. And they went to the fire academy. Then they became paramedics. They ended up doing a documentary about all of us 10 years ago. And just 2 weeks ago, we had the second installment of that documentary. And these young men and women are now working in our community, one of which, a young lady, is right here in the Tenderloin and working. And these were young people that people had counted out, that they decided they weren't worth putting any energy into. And so rather than telling them what they couldn't do, we started talking about what they could do. So that's one of the things that I miss about state court, is that I felt I had more opportunity to be creative, to have judicial partnerships. And I haven't worked on some of the reentry courts, so I can't speak to that. But that was one of the things that I missed the most, is that part of my life where, I was able to be a community member, but also be a bench officer as well.
Has the transition been difficult because you now have to cover a lot of different areas of law?
I actually enjoy learning all of these new areas of law. What is probably more challenging was that I didn't come from what I call the federal family. So I was kind of this unicorn that showed up. And I don't share everything that I've done. And so people assume that the capsule that they hear is the four corners of who I am. And it's not until they see me out in the community or during my induction, when we had the legacy members in the audience from the Brown versus Board, their grandchildren were in my audience, Karen Korematsu, different individuals that I grew up with in the community in Oakland, and I worked as an agricultural worker for a period of time as a teenager. And these individuals were in the courtroom, and the pride that they felt in seeing that someone who started very humble could be in this position. And that for me was pretty startling to see their pride juxtaposed to how long it took for me to be accepted as a member of the federal bench in terms of the testing that I went through. And I'll just give you one example, only because my CRD loves this one, where someone came in and decided they were going to sing to me. So, Your Honor, today we're going to do a 12B motion. That's a motion to dismiss. And I smiled and I said, well, I graduated Sesame Street a little while ago. You don't have to sing, but now, counsel, can you answer these following questions? And it was, I approach it all with humor. And Randy, so you've been witness to many of things, and just showing that grace and meeting people where they are as opposed to where I am, and just realizing I'm new, I'm different. And so rather than fight that, I embrace it, and I hope people give me an opportunity to let them know who I am in all dimensions, not just when I'm sitting on the bench.
Okay, thank you. Judge Lee, what's the transition been like for you?
It's busy. No, I'm just piggybacking on some of the things which Judge Thompson was just talking about. I mean, I think things which I miss in terms of being in the community in that way. So, starting out having a criminal misdemeanor calendar, you might have 100 lines that day, right? You're seeing 100 cases, you're seeing people, you're seeing families, you're seeing defendants, you're seeing people from across the community. And so I do miss that. It's also the reality of the volume was so high in state court. So similarly, when I started in a civil direct calendar, so single assignment, the volume was 1,400 cases, which were singly assigned to me, all motions, 10 to 15 motions a week. And so the difference has been greater resources, probably less cases, but a distance from the community to some degree, and that is something I miss across the board. But I think there's so much of judging or being in the community which carries forward. So, I still have those moments where it's really important that that you have a pro se litigant who, as a judge who's worked in the community in that manner, is able to communicate and try to be as clear as possible in terms of expectations to that pro se litigant, or in the same way of just managing a courtroom. A lot of those things are transferable, and so I feel very fortunate of having the years which I had in Alameda County, which I could bring over. And I feel very fortunate about the resources, my law clerks, my staff, and then the warm welcome. I think all of us have gotten an incredibly warm welcome in San Jose, even if my practice was much more in San Francisco and then somewhat in Alameda County. I had a number of cases in Santa Clara when I was at Kecker, but it's been really nice going back to the South Bay as well, and the courthouse has made it exceptional.
Okay. Judge Weiss, what's it been like for you?
I do not have anything to add to what's already been said.
Nothing? Okay. Judge Pitts, you and Judge Martinez-Alquin didn't come from state court. Has the transition been difficult for you?
I mean, I think we've all faced challenges in the transition, and we're all coming from different places. I think that for me, the biggest challenges are maybe not the things you would expect, like Judge Thompson, and I think I love the variety of practice of areas that I cover. Part of the thing that really drew me to the job was getting involved in all of these areas of the law that I didn't have as part of my practice at Altshuler-Burzon. And I was lucky there to have an incredibly diverse practice that covered a lot of areas, but we didn't do criminal law, we didn't do patent law, there were areas we didn't do, and it's been really interesting. And it's a new challenge that I've really enjoyed, and that's been fun. It's been interesting. The two things I think that have been the most interesting and challenging for me, one is, your life as a litigator is a life determined by external deadlines. And I long ago learned, part of the reason I decided not to become a law professor way back in the day, is that I need external deadlines. I need someone telling me when something has to be done. And it just be looking at a blank page saying I should write a law review article was not the kind of motivation I need. And if you're a litigator, being motivated by external deadlines and external requirements is a really great personality to have, because that's the definition of how you navigate through life. As a judge, especially on the federal bench, we have goals, we have events, we have hearings we have to be ready for, we can set, but you're still, your own personal sense of how long should it be between a hearing and an order issuing, and what is the balance between getting the order out very quickly, but also getting an order out that you think adequately addresses all of the issues, makes the parties on both sides feel like they've been heard, is one that the public can understand if they find it and want to have a sense of the decision you're making. There's all these different values, and it's up to me. There's not really, other than having to report every 6 months, any motion that's been pending for 6 months or more, there's not a lot. And again, just a report that goes to Congress, and that's about it. That's been really interesting to realize that the challenge in sort of going from being a litigator, just responding to, when did the judge tell me to get that done? When did we agree with the other side that would be done? To, okay, now I need to set those priorities and work with my clerks and figure, and also, think about my clerk's quality of life, and sort of there's all these things. So that's been interesting. And I think the other thing is, I didn't have the experience on the bench that three of my colleagues here had, and I don't think, I haven't found like I'm at sea when I'm in the courtroom or something like that, but I remember when I was learning to be an oral advocate, the lesson was you have to be yourself, but it's a version of yourself, and it's a version of yourself situated to, in that case, arguing for your client's interests before a judge or before a panel of judges, and it takes time to sort of feel out exactly what is that balance. You're still yourself, but you're yourself in a way that's appropriate for the context. And I still think this is a new role, and so the person I was as an oral advocate is not the person I am as a judge. And so just thinking through, okay, who am I? And I'm going to be myself on the bench. I can't pretend not to be myself. I always, on days when I think I've been angry on the bench and I've gotten like mean to people, my law clerks are always like, Judge, you're still pretty nice, you're still pretty gentle, and that's kind of my personality, and so that's not going to change. But learning that, there are times that some firmness and some sternness is necessary, and just figuring out what exactly is that version of myself that is the person on the bench.
And Martinez Oakland, you weren't on the bench prior, so how's the transition been for you being a judge? And you're in San Francisco as well as Oakland.
I was going to say that to some degree it looks like, oh, I don't have the mic.
And I should say, Martinez Olquin.
It's okay. I thank you though. So yeah, let me add, right, as you've heard us sort of describe, you've got Judge Thompson and I who are in San Francisco, and folks to my left who are in San Jose, but I should say you also have some Oakland in the house to the degree that my criminal docket builds from the East Bay. So as some of you know, you appear in front of me in Oakland for criminal matters. So I actually love the way Judge Pitts has described it and the way I normally think of that, or I'm reminded of it, and have sort of thought about my time on the bench so far, and I'm still not done with it, but right, so I'm approaching 3 years on the bench, and the only upside to what I heard you all describe is what can be that long period of time between nomination and ultimate confirmation, is that you get to start to think about what you actually might do when you get on the bench, if you get on the bench. And in talking with folks who had been judges before, or who were judges, one of the things that I was told that I should expect would be a challenge, is in fact finding what is known as the judicial voice, right? I know who I am, I know how I interact with people. To riff on something Judge Thompson said, right, I knew how to clap back as a lawyer when someone came for me. When an attorney comes for me and I'm wearing my robe, I have to sort of pause and think about whether or not clapback is even actually appropriate, right? Because I know what I would like to say. And then you sort of have to think about it. And I'd like to think sometimes that that's really what the robe is for, right? We all talk about, and I think I read it for the first time in an article by Judge Chen about the fact that judges wear black robes as a reminder to the people in front of whom they are appearing, that what's underneath is not that important, right? We all put on this black robe so that you have a sense that it is the court and our job is to apply the law, and that's what we're here for. All right, but when the lawyers come for me, I literally, sometimes I'm looking down at my sleeves. It's like, yes, I have my robe on. So I feel like part of what, right, it took lots of years to figure out who I wanted to emulate and who I wanted to be as a lawyer, as a litigator. And that's the piece that I think is still interesting and still a challenge as a judge, is figuring out not just who I'm looking to emulate, but sort of how to really manifest the judge I want to be. And some of that morphs and changes over time. So I have a feeling that, and I may be wrong, but I get from my colleagues, it is really nice being surrounded by the portraits, that it's a thing that they also are, right? It's evolving and changing in the way that people in general sort of evolve and change over time. So my sense is that it is part of the challenge. It is a distinct challenge when you assume the bench without having been a judge before, or this bench without having been a judge before. I imagine maybe you all had that when you joined the Alameda Superior Courts. But I imagine that it's a challenge we will all sort of continue to take with us as we go forward.
Absolutely.
Thank you. There are many attorneys in this courtroom. I think we're around 100 today. Some have appeared in front of you, but probably many more will appear. What do each of you think the practitioners should know about how you handle your courtroom? What takeaway?
For my courtroom, because I guess you're going straight down.
Yes, thank you.
For my courtroom, particularly on the civil side, if I know that there is an attorney who has 5 years or less experience, usually they'll communicate that to my CRD, and he'll let me know that, okay, they want oral argument, it's a younger attorney, and I'll slow down. And I'll tell my staff, okay, I'm gonna draft some questions. And I said, I have to make it make sense. And I want the attorneys to come in and be calm when they're giving their presentation. I don't want you worried about whether you know what the rub is or what the court wants to know, and I'm not going to constantly interrupt you. I'm going to give the questions ahead of time. they're going to be on the docket so that they have at least the weekend, maybe a court day, to kind of mull over those questions. And then when they come in, I'll say, counsel, please answer my questions, and you can either answer them in the order in which you've prepared, or you can answer those first. Because usually if I'm giving questions, it's the one area where maybe there was some ambiguity in the briefing or a gap, and I don't want the attorney sweating over that. I want them to be able to give their best presentation. So that's one thing. The other thing is I do give schedules immediately at case management conference. And I don't continue initial case management conferences, because I think it's important for the attorneys to kind of have an idea where we're going. And because I tried a lot of cases, I start with the jury instructions. I tell people that all the time. I said, I see you're squabbling over discovery, or you're fighting about this, that, and the other, but the jury's never going to hear about this. So can we kind of narrow the issues and focus on what we really need to talk about? And each case management conference, I'm building on that. I'm looking at those jury instructions again, and I'm trying to see, can we narrow the issues? Are you closer to settlement? Is this about you, or is it about the litigation? And I think that, for me, that's an exciting way to go about it. I teach at night, and you probably have heard that theme throughout, that we've all been professors or teachers. I learn from you, and when I go back to my classes in the evening and I see where there's some challenges, I tell my students, I don't want you feeling that trepidation when you come in. Let's talk about what this aspect of the case is going to be like, and so that they're fortified when they reach the courtrooms. And so if I'm ever a little strict, it's more when someone waits until that very last minute to ask for a continuance, or that very last minute, because they don't realize a lot of work has gone into preparing for your hearing, so that I'm fully present and I'm listening, and particularly if it's a young lawyer, to be able to kind of guide the conversation in a way that they're not overwhelmed.
So, as a litigator, sorry, I keep forgetting to turn the mic back on. As a litigator, my practice took me to lots of federal courtrooms across the country. So when I showed up to court, I knew to not arrive, I thought of it as a carpetbagger, right? I had read the local rules, I had talked with local counsel, I knew what that judge, I knew at least their practices. I did not send to the Western District of Kentucky a letter because it was allowed in the Southern District of New York. So please don't show up in my courtroom not having read the local rules, my standing order. I have very little patience for it, because I spent 10, 15 years litigating for judges all over this country, and I did not show up unprepared for that. I'm not patient with it. I'm not. I wish I were as prepared as Judge Thompson is. Right? I think I have managed to post questions to the docket maybe 7 times, and that's being generous to myself and my clerks. I think we've managed to do it a handful of times in a handful of cases. Otherwise, I'm trying to just learn as much as I possibly can from your papers in anticipation of the hearing. And so this is what I do. When I come out and I've got a pending motion or motions, I have a number of questions just based on everything that you have submitted, right? So I will start there. I'm going to ask all the questions that I have first, and then I'll give you all an opportunity to make whatever presentation you would like. Tell me the things that I missed. Tell me what I should be paying attention to that I didn't pay attention to. Sometimes folks have lots to say thereafter, sometimes they don't, and either way, I'm grateful both ways, because invariably sometimes someone actually does bring up something that we hadn't focused on, but that they think is important, and it's helpful. It's tremendously helpful for you all to crystallize that for us. The other thing that I think I just would like for you all to know and realize, and this is where I'm gonna parrot something I heard either Judge Gilliam or Judge Gonzalez-Rogers say, which is, I realize that the standing orders may seem persnickety, and that Judge Thompson may want something different than I do, may want something different than Judge Pitts, Judge Lee or Judge Wise, but here's the thing. We're all asking for what will make our jobs easier to get you answers faster. So please don't incorporate things by reference because you want me to go back and dig out the thing from the docket like 3 months ago. I'm sorry, no, if it's that important, you write it down. I don't have time to go dig that out. Or we will slow you down. We will literally we're gonna move, well, that later, maybe that's tomorrow, right? There are these things that are in my standing order. And like, we're all actively working to try and get things to you as quickly as possible. So help us, help you. Thank you.
I mean, I was literally saying, it seems obvious, but read the standing orders and comply with the standing order. You know, and as simple as some provisions, some of us have put at least one provision at the very top of our public website, just because in mind, hearings are going to be in person unless you seek authorization in advance for it to be on Zoom. It's just very straightforward, and I have a pretty low bar for authorizing Zoom hearings, but if you don't do that, it's in person, and nonetheless, every week or two, someone shows up on Zoom thinking it was on Zoom without that. So read the standing orders. Simple, we're all gonna say it, and comply with the standing orders. I think beyond that, things I would want people to know. One is that, you know, I learned in incredibly intense litigation over many years that was, you know, high stakes litigation, incredibly ideologically charged litigation. I managed to do that litigation. I learned this from my colleagues at the firm in a way that I retained good civil relationships with opposing counsel, many of whom reached out to me when I was nominated to say they were excited to see that I'd been nominated. And, you know, some of these people I'd been in 2.5-year fights. I was representing the talent agents or representing the writers in Hollywood when they were having this massive fight with all of the talent agencies. And this is, you know, the big UA and WME and these huge companies, and it was high stakes. Opposing counsel reached out and said they really, you know, they were excited. We had a good working relationship. And so I really value that in the attorneys who are appearing before me. So I expect that, and we have rules that require that. The other thing that I think I want people to know is that, you know, that is not just in my interest. It's not just sort of for the value of civility in its own sake. It's really in your own interest. In one sense, having been a litigator and remembering that there was nothing more frustrating than when an opposing counsel who was very experienced and with whom I had a good relationship and I figured out the best way to litigate a case, and then we presented it to the judge, and the judge said, I have a different idea for how this case should be litigated. You know, I remember being frustrated by that, and I take from that where parties are working well together and are experienced and have a working relationship, I'm going to give a great degree of deference to the party's understanding of what the best way to litigate a case is going to be from their perspective. And so if you have that relationship, you're more likely to get that. If you don't have that relationship, it's going to be, I'm going to have to figure out how this case can be litigated because I can't get anything from the parties in terms of actually getting that guidance. And so that's in your interest. And the other real point about this is that when parties are not engaging in that way with one another, it makes it difficult both for us as judges and oftentimes for you as lawyers to figure out which fights are the ones that really matter. You know, if you're fighting over 2/3 of the jury instructions, the proposed jury instructions, and in it there are minor little differences in language, or just you know, and we have to have an argument at the pretrial conference about every single instruction, you may not realize that actually there are two that if I rule one way, half the case is out. And so that might get deferred to the charging conference. It's hard for me to pick that up. You may be thinking about all this stuff so much that you don't realize, hey, this is the one that really matters. Like, we should be spending all our time on that issue. And so I actually think it obscures for us as judges who will get all of this stuff, and we have to figure out what is going to be the dispositive thing, like, as opposed to this is just a fight that doesn't really matter. But it also, I think it's in part because the parties don't always see what is the really core meat of the case. And that's what you want. You want to be focusing on that, figuring out your differences, and then presenting them to us for resolution. So I think that's key. And the other point I would make about being in my courtroom, kind of like Judge Martinez-Holguin, I go into oral argument on usually on motions. I've read all the briefs. I've had a bench memo prepared, I've talked about the case with my law clerk, so I know the case very well, but I actually usually go in trying to not have crystallized, a strong sense of how I'm going to rule. Part of my process is to go in and use oral argument as a conversation and engagement with both sides to help further crystallize my thinking. And so that's what I'm looking for in oral argument. It's sort of similar. I'm very bad at letting people go for too long before I just dive in and start talking with them and asking questions. And that's because that's how I'm learning, that's how I'm thinking, that's how I'm processing and crystallizing. And to be very frank, that's also, there are some cases that it's done by the end of that and I kind of know where it is. There are some that process continues through the writing process, that it's not until I've actually written something with my law clerk from beginning to end that I think I can identify all the holes, I go through that I'm doing that. But that's kind of my process, and so that's how motions arguments generally fit into the process for me.
Well, let me I'll touch upon the things which have been touched upon, and on my own riff, I'm sort of in between in terms of the different styles. So as to law and motion argument, I would say about half the time you're receiving an email from my CRD which says the court is inclined to grant this, deny this, it will lay it out with some questions at the end. The other half the time you may not hear from me, and it usually is because we're pondering, we're thinking about it. I do come off attentive. It is an engagement tool. It's because it's to give you a sense of where we're headed, or to give you a sense of, hey, kind of pick and choose your battles, which is a whole nother, I will build upon what Judge Pitt said. But in terms of argument itself, I do engage, I do ask a lot of questions. It is not to be, I'm not your opposing counsel. I'm asking this because I am really curious. There are sometimes I can see the defensive posture start, and I'm like, no, this is actually to your benefit. If I'm asking these questions because I really want to understand fully, something which has been coming up a lot recently, which has been driving me crazy, is counsel, is that case cited in your brief? Is it cited anywhere in your reply brief? I don't know. And then a little later, it's not. I mean, you should know what's cited in your briefs. And if you're citing new authority, you need to give your opposing counsel and the court a heads up. So I also encourage younger attorneys to speak up, as Judge Thompson has mentioned. I think we all do actually on this panel. And if you have your younger associates speak up and then you want to come to point out different things afterwards or do a little clean sweep at the end, that's absolutely fine. I'll let you split your time. So those are but in general, we've been doing a lot of oral arguments, in part because sort of encourage just to get our bearings, but do inform us as if whether or not they're younger attorneys who are going to be speaking. It's a good heads up. So that's that. Standing order, standing order, standing order. Yes, I agree with everything which has been said. I agree with the point of it not being persnickety, not doing it to be persnickety. It really is if I'm getting into a pretty heavy duty motions, if it's something or trial, I do want my courtesy copies. I know I'm old fashioned that way, but it's in the standing order. And then when we're sitting there and we have massive, 10 Dalberts and all these exhibits and cross motions for summary judgments, and then we don't have the courtesy copies, and that's what my chambers uses, then we're all like, and then you're rushing them over, and then we're behind in terms of the prep. So just look at our standing orders. What else was touched upon about all the different topics? Meet and confer. This year, I just added a meet and confer requirements before motions are filed. My major reason of doing that in terms of this round, this year too, was because of the number of times during argument when I'd say, counsel, are you conceding this? Because you didn't really out the 10 different things which were raised in the motion to dismiss, the 10 different claims, you didn't say anything in response to this one. Oh no, Judge, we submit on that. Then why did I just research that? So if it's something you're going to concede it. If it's something which, and my hope with the meet and confer requirement is not to emulate CD Cal per se, but I'm fine doing that. That it's really to try to encourage a narrowing, going back to this notion of narrowing of issues, as much as we can narrow issues. I mean, the volume which we see, the volume of motion practice, the great increase in terms of the motions to dismiss in the past 10 to 15 years, it's a lot for our staff. And what we want to do is be able to spend time to really get in there. All of us, really want to get in there in terms of the thoughtful conversations. We're lucky to be in district. We're on the cutting edge of so many different issues. But if we are dealing with a bunch of tickety-tackety stuff, we don't have time to dive into everything to the same level or that cutting edge issue on the same level you may want us to.
There's so many things that were already covered here. I guess I'll take a very different tack then, because I agree with what my colleagues have said. My experience is that many lawyers, certainly not all, but many tend to have a bit of a type A personality. I don't know if that resonates with anyone here. Judges come from being lawyers first. I think that, sometimes it can hover towards the A+. I strive to the A- and B+ in this regard. My clerks think that's funny and think there's no chance. But how that manifests for this is that, I sincerely believe that I'm here to serve you. I'm here to serve your clients. I'm here to serve the people. And how my personality and how that obligation manifests itself is that you're only here, and I'm talking primarily right now about civil because, not that I'm not here to serve everybody, but right now our docket, for me, it's probably 98% civil in San Jose. It's quite high in that regard. You're only here because you have not been able to resolve your case despite your best efforts. You've done what you could do. I believe that is true. You didn't file until you felt like you needed to file, and you need the court to do something to move your case along. My job is to do that. My job is to efficiently move your case along, to rule on every motion efficiently and as justly and as fulsomely as I can within the boundaries of the volume that we are all managing. And so I tend to, from the very beginning, to get you on a schedule that I intend to keep. Not unreasonably so, but I happen to actually really like going to trial. I realize that's not something here in federal court that seems to happen as much, but I've had one already. I would be in trial again right now, but for what's happening with our budget on when we're going to be freed up again for jury trials, I'm not quite sure. But I say this just as a very practical thing, at least as it relates to me. I am not unreasonable. If there are reasons why you need more time, it's fine. But before you just file a stipulation that says you need 2 more months to file a response to a brief, or you need an extra 20 pages because your issue is complicated, sometimes that's all I get that's in it. I know that having dates generally that are firm help you settle your cases. It helps to give you structure around that. So all I would say in terms of a practical tip is that if there is something that you want from me that strays outside of that, explain it to me. Just tell me why. If you're double set someplace else and you need something else, that's fine. But let me know why it's 2 months and not 2 weeks. So I would say that's the only, I agree with everything else. And read the standing order. There you go.
Okay. Thank you. One issue that is facing the courts is AI written briefs. Has this been an issue with your court?
It has. It has. I probably take a more gentle approach to it. My term clerks don't feel very gentle about it. And usually what I will do is I will issue an order for clarification. When I see that there is an AI-generated quote in some of the briefing, I actually take a screenshot of that particular item, and then I will let the litigant know I couldn't find this. Perhaps you had the wrong page, perhaps something. But I give a courtesy and I say, please clarify this for me. And when I see you at the case management conference, if it's coming up really fast, I would really love for you to explain what happened. And most times, more times than not, I will get a corrected brief. So that's a courtesy. If I see it again, however, now we're in a whole different conversation. And even with the courtesy asking for clarification, I will have the professional rules listed. I will have the ABA standards listed. And I may even reference the person to a case where it's happened before. I didn't see it that often in the beginning, but I'm seeing it with more frequency now. And it's interesting, in teaching, the students are now telling me how I can find ChatGPT references in a brief and how I can find the AI, because I guess they're now watermarking everything. So there's a way that this can get discovered. And I realize people are time pressed, or maybe they're relying on what they believe to be the automated and more advanced technology, but you are still responsible for reading those cases. You're still responsible for looking up those seminal cases. And that's usually the big flag for me. You know, we've read so many briefs now on different subjects, and I try to cluster in my department where I'm looking at Song-Beverly cases for a week, and I'm looking at patent cases for a week. So I'm seeing a range of briefs, and you start to see the same seminal cases quoted. When I see something that's totally aberrant, I'm slowing down, like, wait a minute, this wasn't in any of the briefs that I've ever seen or the cases I've read, so let me pull the case. And then when I can't even pull the case, it's an even larger problem. So it is happening, it is starting to happen with more frequency, and you get a clarifying request from me. It gets a little tricky when the case has just settled and we have a brief that was full of it. And we have to figure out how we're going to approach that after settlement. So you may get a courtesy letter that just says, counsel, I would like some feedback on what happened, so that we understand what's going on. Because it's not fair to your client, it's not fair to the opposing counsel, and it eats up an enormous amount of time for the court. But most importantly, you can really mislead the court, which is an ethical violation. And there has to be a response for that. Your opposing counsel then now doesn't have trust in you. And one thing about being a lawyer, your largest asset is your credibility. That's your largest asset. It takes years to get that. It takes years to, carry that. And then it takes only a few minutes for you to be at ground zero in the negative. So there's no reason for that. So please be sure that you're reading your briefs. And just like my colleague said, when I ask a question and I say, well, counsel, I read this in your brief, and I went line by line in one session, and the person kept saying, no, I don't know what you're talking about. I'm not conceding that. And I said, I'm reading this right out of your brief. What are you talking about? And when you're realizing that we're staying up all night, we're getting in the courthouse early to make sure that we're well prepared for your hearing, it's pretty startling when we see something or hear something that lets us know that we can't rely on what has been presented to us.
Is the court as a whole considering taking an action regarding AI?
I think right now, everything is kind of data-driven as far as I can tell. And I think that, like I said, sometimes it started off as just a one-off, you only saw it once in a while. I'm seeing it with more frequency. I think if more judges see it with some frequency, there may be a more organized or more intense discussion about it. But I can say, having talked to my colleagues who are not in this district, our district, I'm very proud to say, does not have the frequency or intensity of some of the problems that I've heard about in districts outside of the Northern District. So I do applaud the caliber of lawyers that have come before me. I've only had it happen 3 times, but 3 times is 3 times too many. And I've heard other colleagues mention it.
The only thing I'll add is that the recent time that we discovered what ended up being what were our hallucinated cases, Counsel didn't even realize he had done it and seemed to think that that was what made it okay. Meaning, he had Googled something and hadn't realized that Google now has an AI-generated, whatever you call it, that thing at the top now that I go past because I don't trust it, straight to the results. But he had pulled something from there, put it into his brief. He didn't realize he had used AI. He told me literally, right? He's like, I didn't realize I'd done it till I talked with my son who said, you know, Google uses AI, right? And here's the thing that I would say to all of you, just in case there's 2 points here. One, you have an obligation to read everything in your brief. You are certifying under Rule 11 every time you sign a pleading that you have read, that you know that everything there is supported by law or fact. So it doesn't matter that he didn't know he used AI. He's still violating Rule 11, right? That's how that goes. The other piece, shoot, I lost the other piece, which was more, I can't remember what it is. I'll pass the mic. And there was one more thing that I wanted to make sure, but.
I mean, I've had a limited, again, I think, go ahead.
A reminder for those of you who are licensed in California, that the California rules of professional responsibility require you to be up to speed on all the tech. I don't know how this technology works is also an ethical violation. Thank you. That was the other thing.
So I've had, again, like, I think it's right that we are seeing a little less of it so far as we know, in the court. The other thing is, one thing people should know, there are actually pretty simple tools we have available in Westlaw to put a brief in. It's, effectively a Westlaw site checking tool, which you don't rely on entirely, but will tell you if something is full of fake citations very quickly. The thing is, my limited experience with it, and this is where I think there's a real challenge, unsurprisingly was in a pro se case. And I think it reflects this issue. There's this underlying issue of access to legal representation, access to legal resources. I mean, what was so interesting about this is that there was a real insistence and belief that the things that had been cited were real and existed and they were there. But, I was saying, in the context of saying, as much as like, no, this is clearly like what Judge Pitts said in X decision in 2021. If you go back to the start of our conversation today, I was still practicing law at Altshuler-Burzon in 2021. I certainly wasn't issuing any decisions for the Northern District of California. And so I see that and I'm like, okay. But but the people using these tools don't necessarily have the sophistication to understand this. And the interesting thing in this one too, that they were convinced the other side was citing things that didn't exist because, that volume of F sub 4th doesn't exist yet. And it may in fact be that the printed volume of F sub 4th is not available yet in the local law library, but everyone who has access to Westlaw can go and find it. And that was interesting because I actually issued an order saying, I've seen these cases, they exist, they're not making up cases, but I ordered this other side that cited them to issue a supplemental notice with PDFs of each of those decisions, just so that the other side, there's this, underlying this are all these questions of access to legal tools, legal research, and then there's a difficult problem there in terms of the potential for these tools to make the law much more accessible to people, but needing to make sure they know what they're doing with it.
I feel like we've.
Anything to add to it?
Nothing to add. I mean, I've seen it a couple of times. Thankful I have not seen it that many times. Judge Thompson has a kind approach. I would hope that I would be as kind. I may not be. The years of teaching ethics. So, ditto to everything which is said. I think it does raise interesting questions regarding access to justice as well. So.
Nothing, okay. I wanted to talk for a moment about litigation funding. One of our attendees wrote an email last night. What is the approach of the court towards litigation funding? It's something I knew nothing about.
Approach-wise, I think it's case by case. I only had it come up when one of the attorneys says, we're close to settling and we have a litigation funder. And that was the first time I heard that. And I said, wait a minute, the litigation funder has something to do with whether this case is going to settle or not. The second time it came up was in a class action case. and there was a reference to a litigation funder. So then what I started doing was asking for those disclosures up front. And I do ask at case management, is there another party that's involved in this that may have an impact on this case reaching a settlement? And I'll say, I know that you're going to private mediation. I know that you're going to to one of our magistrate judges. Have you provided the magistrate judge or the mediator with a list of all the necessary parties and decision makers? That was one of the ways that I thought I could at least kind of tease that out. Litigation funders is still kind of a unknown quantity for a lot of people, but there's a lot of law firms that have found that to be a way to be able to fund representation when they're taking things perhaps on a contingency basis, or it seems like it's becoming the norm. So what I started doing with my staff, and I said, okay, don't assume anything. Let's get educated on what this is, how it impacts litigation, and what are the kinds of questions that we should be asking, if we should be asking questions at all. And I left it somewhat open because I think that until we really know the impact of litigation funding and whether there are conflicts of interest, whether there are ethical considerations, whether there are individuals who are serving as mediators, but also are part of a cluster of litigation funders, whether someone's hedging bets on a class action and someone's paid out, but there's still a named plaintiff and the litigation funder is still part of the picture. These were some of the things that kind of surfaced. And as we did our research, trying to understand the role of a litigation funder. And unless counsel brings that to our attention, we don't know. So we can't in any way monitor or decide or even comment on what the impact is or isn't if we're not educated by the counsel that's before us. So if it's an issue in their cases, in case management, joint statements, in discovery letters, in settlement letters that are confidential for the judge or the mediator,
I mean, we recently did amend our local rules, our civil local rules, to make it clear that the court interprets the obligation that exists under the federal rules as well as under our local rules to disclose any party with a financial interest in the litigation, to require the disclosure of any litigation funder at the outset of the case with your financial disclosure. So we made it clear that, at least as we understand the local rule, or the federal civil rules of civil procedure, and certainly as we understand our local rule on disclosure, and I'm not sure that there's any other court in the country that is as explicit now as about requiring the disclosure of litigation funders who have an interest in the outcome of the litigation at the outset, which is part of ensuring that and maybe it's unlikely, but that we use that to determine if we're conflicted in a particular case because the outcome could have an impact in a way that creates a conflict of interest for us. But we recently put those rules up for public comment. We didn't receive any pushback or comments on it, so that will, if it's not already up on the website, I think in the near future you'll see that amendment to our local rules. So I think that's clear. There's a separate question posed, which is, to what extent should the other party get to see the terms of that agreement? To what extent is that, should that be in the public record? And I think, that's a sort of going to be a judge and case by case specific analysis, depending on if it has relevance to the issues in the case, if it bears upon what's going on in the case. And there may be judges who believe that should always be public, that should always be shared with the other side. There may be others who take a different view. You can imagine if all of these things, you kind of have to think from both sides. So this is not just a question of who's funding the plaintiff in a particular case, you might think, okay, what are all the financial circumstances that exist on the defense side of the case? And are we going, if we get that block of all of the different entities that may have an interest in a, corporate party or a party before us, how deeply are we going to explore on that side the nature of the relationship that exists between every investor that was ever in the particular company that's now before us? That would be, so you have to think about it. I'm kind of thinking about it on both sides, but I do think, it is something that's out there, and I do think a lot of our colleagues are really aware of it, and certainly where it has a potential to influence the outcome of the case and get settlement or otherwise, it is something that judges take seriously. And I think our magistrate judges in particular, I think, have identified it as an issue because it is often in the context of settlement conferences that they are the ones who suddenly realize there's another party that whose approval the settlement is contingent on, which whether that's ethical or not is a different question. But.
And I just want to make it plain. I think we all know whenever someone has to ask, is this appropriate or should I do that? They probably know the answer. And in one of the cases I had, they were like, oh, well, you told us at the beginning of the case you wanted to know whether we had a litigation funder. We didn't get that person till later. So it's an ongoing obligation. It doesn't just begin at the time that you file a complaint. It's an ongoing obligation. So keep that in mind. And that, that's something that if you feel that it needs to be addressed, you have to frame these issues so that we can make an informed decision. And just as Judge Pitts was saying, we don't want to create a whole nother area of controversy where there is none, but you have an ethical obligation that, trust me, it will raise its head at a time and a moment you don't want it to. And so why even take that risk? And why put your client at jeopardy? Why put the litigation at jeopardy and also lose the credibility with the court by not adhering to the local rules? And you've heard us talking about standing orders. I tell my staff, if you read the local rules while you're on BART from the time you get on to the time you get off, you're going to know more than some of the folks who are going to be presenting oral argument today. Read those local rules. They give you the annotation to the federal rules, and some of them will even give you the professional responsibility rules so that you know them and adhere to them.
Okay. I wanted to turn for a moment to criminal because we do have some criminal defense attorneys here today. I know Judge Thompson, you've spoken about how you approach sentencing. Are there any words of advice you would give criminal practitioners about how you handle your courtroom and what you expect from us as practitioners?
Want to start at the other end this time?
No, we can start the opposite end.
Should not start at this end. Not just because I'm deferring to the seniority of my colleagues, but our civil calendar, our docket, we inherit largely initially from everyone else, and then slowly, especially in San Jose, build up your criminal calendar. And so the number of criminal cases that I have had, especially through sentencing at this point, is relatively small. So I don't think I have anything that's particularly fruitful to say. I was going back.
Well, you guys have been.
Whoever would like to
I
speak.
think we're going to go this way this time, so you guys.
What would I say? I read the sentencing memorandums very closely. I think we all do. But I read both the PSRs and then everything else which is actually submitted. I dive pretty deep into both the memos which parties present and then follow-up questions which I have. If there's still unanswered questions which I have, I will ask you to further brief it. Sentencing is something which, whether it was on state court or on federal, it's one of the hardest things we do as judges. And I definitely take on the weight of that responsibility in terms of, and I think we all do. But it is, so I would say those points, counsel, in one of my cases recently, defense counsel asks, okay, this seems to be bothering you, and I was like, well, that's actually not what's bothering me, but let's talk about this other. But then they asked if they could do some supplemental briefing, and I did welcome that. I do look at the letters. I'm getting members of the community to speak on your behalf to give us greater context on the person who I'm about to sentence becomes very important. At a certain point, if you keep asking to continue the status, I will ask you to come in at a certain point, not because I'm very mindful, and especially for our panel attorneys who are doing this right now without getting paid, thank you. I am very mindful about how much it costs to come down to San Jose and such generally. So you can tell me that's why, Judge, we don't have a real update for you yet, and frankly speaking, we're not getting paid right now. Fine. If you keep in days when we are getting paid, if you keep kicking it down the road, I may at a certain point say, hey, come on in. What's going on? And it's, again, not to. It's because I think it's important that I know just generally what's happening within your case in that docket. So that's the reason.
I would say the thing I found, I do approach it largely the same way as Judge Lee and I think my colleagues, and learn from Judge Breyer and others who've been doing this a long time and thought really hard and long about how sentencing should go and how serious it is and how it is the hardest and most hardest thing we do and the thing that sits with us the most. The thing I would say is, one thing I've noticed in the 2 years I've been on the bench is that in most things, it's, the criminal lawyers are the most civil lawyers who appear before me, and the civil lawyers are the most criminal at times. But it's interesting that when it comes to sentencing, there can be, and it's not, there's a variation in practice, but sometimes there's definitely, when it comes to sentencing, the tack is that, one side is going to push for the highest possible outcome, the other side is going to push for the lowest possible outcome, and it's like everyone's just hoping I'm not, hoping I'm going to end up somewhere in the middle, or, trying to push me, figure out where the middle is and try to pull me a little bit down or something like that. There's a little bit of that sense of going even farther than you think there's any chance that I would go under the facts of the case, with the goal of sort of getting you down there. And it can end up that both sides are playing that. And that's not particularly helpful to me. As I say, and I always felt and this is different as civil litigator, but the most effective briefs are not just articulating your client's position, but telling a story to the judge about why the outcome in your favor is the story that makes sense. And in the context of sentencing, I think that is really, when it feels like the position a party is offering me, there's a reason, yes, a variance is warranted, but this amount of variance is warranted, as much as I would like to advocate, Your Honor, for time served as a sentence here, I acknowledge that under the circumstances of this case, time served is not a realistic option, and so the option is going to be X. It's like when there is that sense that the parties are really talking to me in the language that I'm going to be thinking about in terms of how to do my sentencing, and talking to each other in that sentence, which is hard given the simultaneous briefing. It's sort of one of the upside of the way civil things happen is you get back and forth, and there's a little more space for that. But I do find when it feels like the sentencing memoranda is talking to me in the language that I am thinking in and acknowledging the problems I'm trying to work through, and then explain why the sentence that they're proposing is the one that comports with that. I find that to be really helpful.
So there's two things that have, I came to the bench without much, if any, experience with criminal law, right? Other than the judge I clerked for handles the Western District of Texas is one of the busiest federal criminal dockets, along with a handful of others across the United States. But other than sort of, being ringside, watching for a couple of years how that went, so I understand the patter of it all, I came without a lot of grounding in it. So here are the things that maybe surprised me. I think given how much we expect the attorneys on the civil side to communicate with the court only through the docket, I'm sort of surprised at the way the attorneys sort of reach out really freely to my CRD and ask my CRD for things that they have no business asking my CRD for, because the person they should be asking for that is me. So I just want to note, I think I'm sort of surprised that parties seem to think that it's cool to email the CRD, and you're copying opposing counsel, which is better than the civil lawyers do sometimes, so kudos for that. Mm-hmm. But you're just like, hey, can we move this to over here? But you haven't asked opposing counsel sometimes, which sort of blows my mind. I don't understand, I guess, why folks aren't sort of talking with each other a little bit more. And I do appreciate the degree to which part of what you're doing is trying to get dates to put into the stip you will ultimately file. I will note for you that all of us have our availability on the website. So maybe one less email to our CRDs would be welcome, right? Like don't email if it's a date that is on the website, because you can look yourself. All right, sentencing.
I was going to say, I'm actually fine with that sort of.
Well,
I let Nicole run my life, and I want her life to be good, and so like there's as long as everyone's on, it's all two-way communications. A little bit of that I'm okay with. So just to be clear.
I'll tell you a story later. So, but as recorded sentencing, I think I do want to echo. I guess there's two things I'll highlight for you all here. I think Judge Pitts is right that, the beauty, it's not beautiful, but just like the nice thing about the way the briefing is staggered on the civil side is that there's less excuse, if no excuse, for not actually addressing each other's points, right? On the criminal side, it is somewhat harder because of the simultaneous briefing. But here's the other part here's the one piece of that I maybe find challenging. You all get the PSR from the probation officer, and then you lodge objections. And so you have previewed for each other what the court is going to see, right? So when you don't address some of the things that the U.S. attorney is going to argue or the defense counsel is going to argue, you're not helping us. You're making it harder because ultimately you are not talking to each other. And I think I find that challenging. I find that sometimes I encounter counsel on both sides who are acting as if there are some facts that don't exist. And that's not helpful to me. And maybe that's what Judge Pitts is describing, is like the folks who are like, sentence way over here. No, sentence way down here. And at some point, again, maybe you're doing it for your client, right? Like I sort of tell myself that there are things that maybe are happening to earn client trust, or I don't know, but it's challenging as the judge to sort of get that, Anyways, so those are maybe the bits and pieces with sentencing. I think for those of you who have appeared in front of me, I'll say this: I think that folks often talk to Diana Weiss, and sometimes she passes little things back on to us. So I will say this because I took it as a compliment, which was, right, one of the members of the CJA panel went to Diana and let her know that no judge had spoken that way to their client, and it was a good thing, right? Like, no one has ever spoken to my client at sentencing, right, or in that way, right? Like, I think what I've found about sentencing is there's a way in which, as is true in the criminal cases more than any, and I get it because your clients aren't going to talk to us, and clients rarely talk to us, criminal or civil. We're talking to the lawyers. But by the time we get to sentencing, that's about the lawyers, but at that point, it's really about the defendant, right? So I'm trying more and more to I used to do it in little bits, and I'm starting more and more to make the entire thing about addressing the criminal defendant, because, right, so much of the beginning of it might sound like it's not for them. We're still arguing about whether this enhancement applies, or, how much do I subtract, like, right, all of those pieces. But I mean, that's I guess what I'm sharing is that I'm trying to accomplish that, because I'll say it one more time because I think you all need to hear it maybe, but it is the hardest thing we do. It may not look that way, but it is the hardest thing we do. And so, because it's a difficult day maybe it's a difficult day for the defendants. So I'm trying to just be as human as possible. And I very much appreciate Judge Thompson's comments. I think this is maybe at the beginning of our time together that I am constantly thinking about the fact that these are folks who are going to rejoin our community, right? So with that in mind, right, I think that sometimes gets lost in the papers too. Not less from, I think defense counsel appreciates it very well, but I do think that I'm appreciative, and I've commended assistant U.S. attorneys who have paused to acknowledge the humanity of the person that is standing on the other side, because I don't always get that, and that shocks me. And I keep it to myself because I'm wearing a black robe when this is happening, but this is a good space in which to say it.
All right. Having tried a number of death penalty cases and having to prepare a case in 2 segments and having to know someone prenatal all the way up until a verdict is reached, you start to realize the different segments of preparation that are needed. And so when you're handling a criminal case, please start with your jury instructions and know where you're going. You don't get in your car and decide you're going to drive to Monte Vista and not know the pathway or detour you might have to take because their street is blocked. So first, please know your pathway. The next thing is, if you're going to do a suppression motion, let us know if you need us to block time for an evidentiary hearing and to give us the basis for that evidentiary hearing, because it's not a given that that's going to happen. Make sure that your briefing is complete. I will probably give you a briefing schedule when I know that you're going to ask for a motion to suppress. As we get close to trial, once I hear in my status hearing that we're going to set a trial date, I'm going to reverse engineer that and give you your dates when I want your jury instructions, your in limine motions, and I will post tentative in limine orders. And they're not to just sit there for you to be able to say, well, Your Honor, we'd like to revisit that, because I'm going to say in 60 days, 30 days, this is going to become your final order, unless I know that you want to deal with some part of it, because some parts are going to be pretty clear, and then there may be some areas that aren't clear. As we get close to trial, I tell people when I'm getting ready for a trial, I give you the time you need on the criminal side. I give you the time you need. But once I have citizens here, we're ready to keep moving, because citizens are coming from hither and yon in order to hear this case, and we don't want them frustrated when they're making probably the most important decision they'll ever make in their lives, short of their family decisions. And we want them focused. We want them without stress. With regards to sentencing, I shared earlier that I do spend a lot of time reading everything, and I recite as much of it as I can on the record so that the attorneys know that their work and their hard work was not unnoticed. If it's boilerplate, I am not happy. So if I have 3 or 4 sentencing memorandums in front of me and I'm seeing the same story, then I have a problem. I'm probably going to engage you a little bit more. I'm going to engage your client a little bit more if you're a defense attorney. And I'm going to tell you one story of why it's important for you to pause and for you to make sure, if there's a language barrier, that you are really slowing down with the interpreter and asking questions. I had a young man in front of me, and because I pretty much know where all of these different facilities are, and what's a hospital, and what's a mental health facility, and what's a place where maybe you're going for some outpatient care. And the individual had actually been institutionalized for a period of time. Was nowhere in any of the memorandum. Nobody had mentioned it. And what they asked was, had you ever seen a doctor? And there was a response, but this was someone with a language barrier. And as I teased it out, I said, well, did you have kind of a timeout where you really couldn't leave? Was there some other things going on? And it was really clear that this person had been what we call 5150. They had been a danger to themselves or a danger to others and were under observation for a period of time. And they came in, and I didn't know whether I could take a plea from this individual. I didn't know whether they understood what was going on. I didn't know if they were fully informed, and couple that with the language barrier. So I just say slow down a little bit. I always give the criminal calendar all of my time on Friday, and I do exhale on Friday because it is true. The criminal bar is so much more civil. They cooperate with each other, they talk to each other, they try to reach stipulations when they need to change dates. They understand that, yes, I'm going to fight hard in the courtroom, and I'm probably going to make your life miserable in the courtroom. But when we take that recess or we take that break, everybody understands that I'm doing my job. And if I am a vigorous advocate on both sides, the judge is going to make the most informed decision. The other thing is, please, when you're doing your sentencing memorandum, if you want variances and downward departures, please use those guidelines and tell us what it is you'd like us to look at. I'm sitting there with 3 stacks of books as I'm trying to figure out my sentencing, and I'm saying, gosh, the attorneys could just tell me which guidelines they'd like me to take a look at, which areas they would like me to consider. If I'm looking at ACEs, is this somebody who's had a really traumatic childhood, and maybe that's something I'm going to consider as a variance? I don't know. But if I don't have that information, it makes me very limited in being able to make an individualized assessment, which is my obligation. So I take that obligation very serious, because we can do restitution on the civil side. We can make sure people get their money. We can make sure they get another bite at the apple. We can make sure that we restore a lot on the civil side. On the criminal side, if we make a mistake, it can be fatal, and we can't give people their days back of their lives. We can't do it. And for a victim, we can't give them peace of mind if we make a mistake. So just keep that in mind when you're working on the criminal side, to slow down. Just slow down. And please don't boilerplate everything. Slow down. And we're going to give you the time, because we're taking that obligation so seriously. And we spend a lot of time toiling over what's the appropriate outcome.
Thank you. I'd like to open it up to questions, but we're over right now, so have to call it quits. For those of you who are law students who are here who had some questions that you wanted me to ask, Judge Pitts' law clerk is here, and he's willing to meet with and answer your questions. So just come up to me and I can connect you. Thank you, and thank you to the judges. It was very informative, and I appreciate your time. Please join us for the reception.